Jeffrey Deen's ever-present desire to hold office as a judge is thankfully always overshadowed by his lack of legal skill and background to that end. On his Twitter page, Jeffrey Deen invokes God, arrogantly moralizes, and sets himself up as smarter and better than others, with of course the occasional rant, and posted several bigoted, racist, and even anti-Semitic tweets showing us who he really is and how he really thinks. The state of Florida has had a long and ugly history of racism, anti-Semitism, and lynchings. Jeffrey Deen himself has stated that he requires the taxpayer-based lawyers who now work under him in his court-appointed taxpayer-based office to drink his particular brand of Kool-Aid, and that he willingly encourages them to be creative to that end. He describes this creative mandate required of his lawyers under him as rope, as a hanging rope.
So I ask people to drink the Kool-Aid for me, and they laugh about it, and then they hopefully drink the Kool-Aid. You have lots of room to be creative, or maybe I'm just giving you rope.
Here, Jeffrey Deen tweets, "Happy Hanukkah" to one of Roy Moore's attorneys. This may seem innocuous, but this is in fact an anti-Semitic statement. This statement is in regards to Jeffrey Deen's long-running outspoken opposition to a political candidate and judge named Roy Moore. Roy Moore's wife publicly referred to an attorney that was once hired by their family as a Jew, and she drew criticism for it, and rightfully so, as she should have. The lawyer was later named Richard Jaffe, and yes, he is Jewish. He later gave a statement in 2016 to the Washington Post where he said that he was certainly disturbed as a member of a minority. Clearly, Mr. Jaffe was expressing his being disturbed at his publicly being referred to as a Jew and as a member of a minority group. So, what does Jeffrey Deen do after Mr. Jaffe publicly makes this statement? Well, Jeffrey Deen tweets, "Happy Hanukkah" to one of Roy Moore's attorneys. Poor Mr. Jaffe, already disturbed as a member of a minority by publicly being referred to as a Jew, now has Jeffrey Deen publicly making what can only be considered an anti-Semitic dig at Mr. Jaffe's religion, which is Jewish, and as a Jewish person, most likely greatly values his religion and the ancient and sacred traditions that are part of it, such as Hanukkah. The U.S. Department of State has roughly defined some aspects of anti-Semitism as anti-Semitism is a certain perception of Jews, rhetorical and physical manifestations of anti-Semitism are directed towards Jewish or non-Jewish individuals. Clearly, Jeffrey Deen's racially charged tweet is his public rhetorical expression manifested and directed towards a Jewish person. In this case, to further insult and degrade Mr. Jaffe. Clearly, Jeffrey Deen thinks this is humorous. But is he really that stupid or insensitive? Most likely yes on both counts. But to publicly make a joke about a Jewish person's religion, who prior publicly voiced that they are disturbed as a minority group at such public degrading statements, is not just bad form, not funny, insensitive, etc., etc., but is actually anti-Semitism to do so. My sincere hope is that Jeffrey Deen is actually really that stupid. On Jeffrey Deen's Twitter page, he tweets, "Can you even comprehend this nonsense?" in reference to a legal case in which a young black man, upon being arrested, asks for legal counsel by saying, "I want a lawyer, dog." He was denied his Sixth Amendment right because law enforcement felt he was actually asking for a dog, that is a lawyer, rather than a lawyer, a regular lawyer, a human lawyer, not a dog lawyer. Clearly he was using black American slang known by all Americans, and certainly he was properly understood by law enforcement, and clearly his request for a lawyer was denied, and is wrong. But Jeffrey Deen here clearly is out of line and is displaying linguistic discrimination, as defined by Wikipedia as linguistic discrimination is the unfair treatment of an individual based solely on his or her use of language. This use of language may include the individual's native language or other characteristics of the person's speech. Perceived judgments may then lead to unjustifiable treatment of the individual. Jeffrey Deen himself and his office are both paid to provide effective legal counsel to the poor, of which many are minorities, such as this young black man who simply wanted a lawyer but got denied one, and as well he was publicly degraded and made out to be a stupid, lesser person, and publicly by Jeffrey Deen as well. Jeffrey Deen is wrong for publicly releasing such a dehumanizing, racially charged tweet. Remember, Jeffrey Deen's very job is to protect the rights of people like this young black man. When this young black man invoked his constitutional right to counsel, he really wasn't asking for counsel, because as a young black man, he is only capable of speaking incomprehensible nonsense. As a court-appointed lawyer, whether he likes it or not, Jeffrey Deen is charged with making sure those, like this young man, receive counsel when asked for it. Taxes from the poor pay Jeffrey Deen's salary. Of all people to degrade this black man for wanting counsel, Jeffrey Deen is the most out of line, as it is his very job to provide him counsel. Jeffrey Deen's language is that of a bigoted racist, humiliating a young black man for his asking for help that Jeffrey Deen is paid for to provide. But it must be known that Jeffrey Deen has outrageous and disgusting language for those who need help in general. Let's look at another tweet. Jeffrey Deen tweets, "The lower end of the gene pool saved again," in reference to people being rescued during a storm. While dehumanizing a young black man for asking for help is really bad, and publicly using anti-Semitic language directed at a Jewish person in the form of a joke who just prior voiced that they were disturbed by such language is just as bad, it is here with this tweet that Jeffrey Deen shows publicly his ideas about humanity and human beings in general. As the head of the 5th District Regional Court-appointed counsel office in Florida, he is tasked with providing the taxpayers of his district effective, fair, unbiased legal representation if they can afford it. This is a very principled and sacred duty Jeffrey Deen is tasked with, and he must show all people in general respect, period. Any person publicly displaying any kind of racial, bigoted, or class elitism is unfit to head any court-appointed legal office that is funded by the taxpayers. One cannot publicly display hatred towards the poor and towards minorities, then claim a promise to defend them. Jeffrey Deen in this tweet clearly displays publicly his ideas about human beings in need of help, and it is that they come in racially classified genetic types. Jeffrey Deen does so here show his thoughts about people in general, that there are human beings at the high end of the gene pool, the middle end of the gene pool, and as his public tweet shows, the lower end of the gene pool. A normal, moral person does not look at that picture of people being rescued and instantly into their heads pop a eugenics-based bigoted thought of their inferiority. It must be known this kind of gene pool language isn't a joke, is the same exact language used by the Nazis to commit the Holocaust against all those that they felt were the low end of the gene pool. This low end of the gene pool language included women and children who were murdered because they were the low end of the gene pool. (1989) Orlando Sentinel article by Debbie Salamone. Jeffrey Deen is described as an inebriated fraternity boy singing Desperado as loud as he could, and that he walked around like he owned the place. Clips from his judge application interview had to be shortened due to constant seemingly refusing to answer questions forthrightly and plainly. Clearly, he doesn't like to explain his empty resume and himself. Take careful note here of his refusal to directly answer the questions put to him. Question 18A on his judge application asked specifically of college academic achievement. Jeffrey Deen wrote, "Unknown."
We look at the applications, the governor's office looks at the applications.
Yes,
I'd like them to be complete.
Yes, sir.
There's a couple areas
Okay.
I'm not sure are complete. 18A talks about secondary schools, colleges, and law schools attended. It asks for schools, class standing, dates of attendance, and degree. Under class standing, you've got unknown next to University of Florida and the law school at Stanford University in Cumberland. Can you help fill us in on what those answers are?
I have no idea what my class standing was at the University of Florida. I believe I was in I didn't want to put an answer that was any kind of, I wasn't comfortable giving an answer like that, so I just didn't.
Okay, related to question 40.
He's asked of his history of filing briefs. It's little to none, and even admits an example brief he attached to his judge application was not even his, but one that he had taken from another attorney. As well, he's forced to admit to only arguing one case period, and that he lost it.
When you're an appellate judge, you have to read briefs, you have to read cases, you have to write opinions.
I have kept cases all the way through. I've kept a small caseload, so I've dealt with the mechanics of retrieving transcripts and things like that. We've dealt with the costs and things. I've written briefs. The most recent brief I've written, I believe I've included in there, I took from one of my lawyers. I try to keep my hand in it a lot. I probably have had, I've taken, during periods of time, I've gone to particular locations.
How many cases in the last 7 years have you actually argued at an appellate level?
Here?
Yeah, where are you there?
Actually argued?
Actually argued.
One.
And how did that turn out?
Of course, I came here and lost.
For just a few short years after college, Jeffrey Deen was a prosecutor intern in Sanford, Florida. His last year there, he actually tried a few felony cases, but then quickly afterwards quit, thinking incorrectly that after just a year trying felony cases, he now immediately deserved to be a sitting judge. The voters wanted absolutely nothing to do with him, and he lost.
I started out in Sanford as an assistant state attorney, as an intern. I worked primarily in misdemeanors. I started in the misdemeanor division, tried cases before I left there in 1990 after I'm going to say stupidly ran for judge way too soon.
Jeffrey Deen is the Sanford prosecutor who in 1989 directly perverted law in order to convict a poor, young black girl, Jennifer Johnson, a mother who was wanting, needing, and asking for help. 1990 Penn Law Review article by Doretta Massardo McGinnis. An attempt to convict Johnson of child abuse was unsuccessful. The prosecutor, Jeffrey Deen, ultimately applied a statute typically used against drug traffickers. His reasoning, seemingly to stop women, Jennifer Johnson, from reproducing through incarceration and probation while the state takes custody of the children. Incarceration of entire maternal family units, en masse. Florida prosecutor Jeff Deen asserted that the goal of prosecuting women who deliver drug-exposed babies is to deter them from having more afflicted children. The nature of addiction makes it unlikely that these prosecutions will have much deterrent value. In addition, the goal of ensuring fetal health may be better served by providing pregnant addicts with drug treatment and prenatal care. It may be that the only goal served by these prosecutions is punishment. The Supreme Court has long recognized that drug addiction is an illness, stating that addicts are diseased and proper subjects for medical treatment. 1991 Yale Law Review article by Lori Rubenstein. She establishes that, first, neither sufficient nor appropriate treatment is available for most pregnant addicts. Second, prosecution actually deters rather than encourages treatment. Treatment opportunities are limited for all drug users. At the time of her arrest, for example, Jennifer Johnson's home state had more than 2,000 people waiting for treatment. More than 600 could not receive treatment within a reasonable time. Pregnant drug users, however, face a more acute shortage of treatment facilities than any other segment of the population. The attempts of Jennifer Johnson, a Florida woman convicted of delivering cocaine to her children, to get treatment, for example, proved helpful only to her prosecutors. They used the resulting paper trail as evidence of her addiction. The insufficiency and inappropriateness of current treatment for pregnant women is made particularly unfortunate by the fact that pregnancy is an optimal time to motivate women to stop using drugs. Jennifer Johnson and Melanie Green both tried without success to enter treatment programs during their pregnancies. Jennifer Johnson's experience is instructive for those who question these fears. Johnson expressed fear about her addiction's effect on the child she was carrying to paramedics, to the doctor who delivered her child, and to child protection workers. The state introduced these conversations at trial as proof of Johnson's cocaine addiction. Unfortunately, these prosecutors, Jeff Deen, views do not comport with reality. Sending messages to pregnant drug users to get treatment will not work because, as the experiences of many of the prosecuted women demonstrate, there is very little treatment available to them. 1992 New York Times article by Tamar Lewin. It's the first Supreme Court in any state to address a conviction of a pregnant woman for giving birth to a substance-exposed newborn. It's significant both because it's a unanimous decision and because now all the courts have ruled on these cases, say they're illegal, unconstitutional, or both. The public health authorities say prosecutions of women like Miss Johnson are misguided and serve more to scare women away from the health care they need than to stop them from using drugs. The American Medical Association, the American Public Health Association, and the National Association for Perinatal Addiction Resources and Education were among the groups filing briefs on Miss Johnson's behalf. The court declines the state's invitation to walk down a path that the law, public policy, reason, and common sense forbid it to tread, the state Supreme Court opinion said. Families and mothers' rights groups and medical bodies across the nation were outraged, with many filing briefs. A unanimous Florida Supreme Court decision threw out the conviction, declaring that Jeffrey Deen walks a path devoid of common sense, reason, public policy, and law. Jeffrey Deen was appointed to his newly created current taxpayer-based job as 5th District Court-appointed counsel by then-Governor Charlie Crist, who himself needed 3 tries to pass the bar exam and is considered by many to be a racist himself. Never showing remorse or apologizing for his disgusting attacks on mothers and children in need of medical treatment, stating in that Orlando Sentinel article that Deen's one regret he left before he could help get enforcement officials and lawyers used to prosecuting more cocaine baby cases. Thankfully, the Florida Supreme Court and all other high courts, along with practically every major medical and family-orientated organization in the entire nation, stepped up and denounced him and protected those mothers and their children from him and his belligerent perversion of law. During that disgusting period in the early 1990s, after Jeffrey Deen thought, incorrectly, that he would quickly and easily be elected a judge, he was forced then to go into private practice and did so with what can only be considered 3 like-minded lawyers, who never once denounced Jeffrey Deen's attacks against mothers and families, but seemingly must have embraced those views because they certainly embraced him with open arms.
His office. That's when I ran for judge, and then after that, me and 2 of my buddies started a law firm. We added one of our other buddies in the early 90s, and that, in some version, is where I was for the next 17 years.
Jeffrey Deen calls them his buddies. If they didn't fully embrace his views, it's unlikely they would have gone into private practice with him and attached their names publicly alongside his. Those 3 lawyers were Stephen Lamar Lawrence, Robert Byron Fisher, and Mark Andrew Fromang. As unbelievable as it seems, Jeffrey Deen, along with these 3, have in recent years started a limited liability corporation called, if one can believe it, Families First Foundation. Jeffrey Deen, along with his 3 lawyer buddies, are now using the tax-funded public defender court-appointed 5th District office he heads and its resources as their personal corporation's headquarters, which seems improper. Here is that tax-funded 5th District office's address, where Jeffrey Deen works and is the lead counsel and runs that office. And here is Jeffrey Deen's Families First Foundation address on file with the state of Florida. These 2 addresses are one and the same. There is no website or any other information anywhere concerning this Families First Foundation. As well, there is no such way to apply for its alleged services, or how they, or even whom they help, if they help anyone at all. It appears to be a simply on paper foundation, with no real tangible benefit seemingly to anyone, of course other than to Jeffrey Deen and his buddies. It must be known that so-called nonprofits like this Families First Foundation are allowed to and do in fact pay salaries to its directors directly from the donations received. Directors with titles such as Jeffrey Deen and his buddies. For 5 years now it has operated seemingly in the shadows, with no public face anywhere, always trying desperately though to collect money, but as stated with no real benefit seemingly to anyone or any family, first or last. Knowing Jeffrey Deen's past of attacking poor minority mothers and their families rather than help them, along with his most recent, just the last 2 years, public anti-Semitic, eugenics-based, bigoted racial slurs, which are outrageous, it becomes clear to anyone paying attention that this private corporation he calls Family First Foundation, seemingly operating improperly on tax-funded dollars, is most likely not fully what he and his buddies claim it to be. Knowing that Jeffrey Deen now feels he deserves to be an appellate judge, who lacks the background and skill to that end, this shadowy Families First Foundation surely looks good on his resume to that end, as well with the potential for an additional salary from this nonprofit for him and his buddies, on top of his already tax-funded salary he currently receives. Jeffrey Deen's past actions show exactly the opposite of really caring about families. It seems he used those poor minority families' plight in desperate need of help as nothing more than a quick and easy stepping stone for himself to try and get into a judge's chair, but thankfully it didn't work. And his public anti-Semitic, bigoted racial rants show without doubt he has not changed at all from his horrific past, but seemingly today has become an even more cocky, arrogant, and dangerously deranged problem for the good people of the state of Florida who pay his salary. The reality of Florida's ugly past of bestial-like lynchings, even of women and children, is not the path that the good people of Florida want, will tolerate, be intimidated, or tricked into accepting and walking down today. Jeffrey Deen's clearly strongly held beliefs of racism, anti-Semitism, and gene pool distinctions, alongside his now decades-long history of attacking minority mothers and children in desperate need, render him unfit to head any court-appointed office funded by the taxpayers of Florida. It seems that Orlando Sentinel article from 1989 describing him as a loud inebriate who acts like he owns the place was spot on. Jeffrey Deen was back then, and even more now today, disgusting and truly unfit.
So I ask people to drink the Kool-Aid for me, and they laugh about it, and then they hopefully drink the Kool-Aid. You have lots of room to be creative, or maybe I'm just giving you rope.